And I'm happy to introduce our next speaker, Professor Stéphanie Laulhé, who is Professor of European Law and Reform and head of the School of Law at UCLan, Cyprus. She is also the director of the Jean Monnet Center of Excellence for the Rule of Law and European Values. And now she is visiting professor at the United Nations Institute for Training and Research. Professor Stéphanie Laulhé will speak about latest regulatory development in AI in Europe. Can you hear us now? Dear Stéphanie?
Yes.
Yes.
Hello, everyone. Good to see everyone. I can't say I listened to everything and understood everything, but I watched the slides, so it was good.
But you had the interpretation. There is a synchronic translation
Yeah,
at the
okay.
right
So
corner.
I joined in the middle, so I
Okay.
missed that part.
For the
Never mind.
next presentation, you can use it.
It's good to see everyone. Thank you, Julia, for the invitation. So do I have the possibility of sharing? Yes, I think
Yes.
I do. The possibility of sharing. So let me share my screen and then you let me know if you actually can see it properly.
Yes, we can see it now.
Very good. Let me try the slideshow as well. So thank you, Julia, for having me. And it's a very nice transition from the previous paper. That was very interesting. So what we said I would do today with Julia, we said that I would actually look into the latest regulatory developments in the field of artificial intelligence in Europe. There is quite a lot to say lately. The summer was a busy period. So let's start with an acknowledgement. Eula and I actually are the authors of a working paper that was published under the Center of Excellence, which I direct. So that working paper, it's actually the inaugural working paper in the working paper series of Prof. And we looked into challenges to fundamental human rights in the age of AI, systems in particular. And we looked at their connection with the rule of law principles and the digital legal order. You can find that paper online freely by actually entering the CROLEF website and going to the working paper series. Now, what do I want to do now with you? I'd like to get inside the European Digital Legal Order, explain what I think this is, and give examples and developments of the European Digital Legal Order, some developments in the EU, some developments at the Council of Europe level, and then perhaps we will draw a little bit of comparison before we move on to looking at the impact of artificial intelligence systems on fundamental human rights. And we consider maybe some new fundamental rights, which is something we developed in the paper. So let's start with the European Digital Legal Order, and let's try to see how this has advanced compared to the ordinary, traditional European legal order, which we all know as of a post-Second World War. So traditionally, the European legal order entails a set of fundamental human rights, but also rule of law principles and democratic values. And these are enshrined in documents that we know well, such as the UN Charter of 1945, the Council of Europe Statute of 1949, as well as the ECHR, the Convention, the EU treaties as they are amended along the line, the EU Charter, which was actually became legally binding together with the latest amendments to the EU treaties via the Treaty of Lisbon, 2009, and the case law of both the Strasbourg Court and the Luxembourg Court. So it all emanates from how capable we are, the Western societies are, because we are talking about Europe. So European societies are to maintain the rule of law. And from maintaining the rule of law will derive the sustainability of democratic values and freedoms under the law enshrined in fundamental human rights. So the three are totally linked. And in Europe, for European societies, there is a variation across those three, but there is an expectation or an assumption that all three aspects of the triangular relationship are present. And this is why we often talk about the rule of law crisis in Europe, because of the lack of triangular relationship between the rule of law, democratic principles and values, and fundamental human rights. And this remains unchanged in the digital world. So the digital world, or the digital legal order in Europe, and not only in Europe, comes and affects, upsets, disturbs, distorts our traditional understanding of the European legal order. And the same questions remain, which is, what is the nature, what is the scope of fundamental human rights? What does it take to uphold fundamental human rights, as well as rule of law principles and democratic values, also in a digital world? So if we try to get inside the European digital legal order and see what exists already, there's quite a lot. I mean, the previous speaker spoke extensively about misinformation and disinformation, and about regulatory attempts around these concepts. And that fits very well within this broader European digital legal order. So if we go inside, then we see that there is no uniform or single definition of artificial intelligence or AI systems in the European legal order at large, meaning outside of the EU, meaning the whole of Europe. But there are several attempts to provide what we call an all-encompassing but change-resistant definitions of AI systems, because everybody agrees with the fact that they have a serious impact on fundamental human rights. So there are different approaches to this uniform or this non-uniform definition. First of all, you have the approach that is enshrined in the European Declaration of Digital Rights and Principles for the Digital Decade, which enshrines, promotes, fosters principles that are clearly deviated or derived from a traditional understanding of human rights, a post-Second World War understanding. So the declaration insists on an anthropocentric interaction. It means where the human being is at the center vis-a-vis AI systems. And the declaration, of course, also insists on the importance and the phenomena of digitalization, as well as algorithmization. So this is at the declaration level. So it's at the more fundamental level. And then when you actually look at the actual instruments of secondary legislation that were created particularly in the EU, you find a more risk-based approach, which exists in the GDPR, in the General Data Protection Regulation. It also exists in the Digital Markets Act, the DMA, and the Digital Services Act, the DSA, and lately in the brand new EU AI Act. And if you compare this to the framework approach of the Council of Europe, particularly as enshrined in the Framework Convention on AI and Human Rights, Democracy, and Rule of Law, which is a brand new framework convention. If you look at Article 2, There is an interesting attempt of a definition of AI systems as a machine-based system that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that may influence physical or virtual environments. Different AI systems vary in their levels of autonomy and adaptiveness after deployment. That is, to me, an interesting initiative and attempt to provide for a framework. I wouldn't maybe call it a definition, but at the very least for a framework delimitation of AI systems and how they relate to us. In any case, this multiplicity or pluralism of understandings of AI systems and approach to them mean that we, as the lawyers and others, researchers in particular, experts in any aspect of AI or any aspect of AI systems, including aspects of, impacts on human rights and rule of law principles and democratic values, as we heard before, we need to re-examine and wonder about potential new or renewed or modernized rights that should enhance or come and supplement the current catalogue of fundamental human rights as contained in the main European human rights instruments, which are the EU Charter and the CHR. And one aspect that we insist a lot in the working paper with Julia is actually the aspects of regulatory standards, especially in relation to AI, that should be made clearer and should not be based on a half-hearted approach. What do we mean by that? We mean should not be over-compromised. Compromised they will be, but over-compromised may be an issue. Now, since we're inside the European Digital Legal Order, let's have a look at the brand new EU AI Act. The regulation that implements the Act was actually published in the official journal of the European Union in July this year. It is therefore a regulation of the European Parliament and the Council of June, 13th of June 2024, laying down harmonized rules on AI and amending a number of regulations. And as such, together, it is actually referred to as the AI Act. Now, before I go on to, expand what is on the slide, I just wanted to remind everyone of what it means to have an EU regulation, just in case you are not very familiar with it. An EU regulation within the EU, among EU member states, is a legally binding act. But not only that, it is an instrument that is directly applicable and generally applicable. So it applies to everyone in the EU and directly to everyone in the EU. So there is very little implementation needed at the national level, although given the length of the document, I mean, the regulation is close to thousands of pages. I strongly suspect that member states will have difficulties to relate to that, and that there may be the need for a little bit of implementation at the national level. Having said that, it's a very strong instrument. This is what I meant to say. It is as strong as the GDPR. But the GDPR was also very long, but not to the extent of the EU AI Act. And the other specificity of the EU AI Act is the fact that it has many different stages of implementation. We will come back to this later. So it's important to note that this EU regulation lays down harmonized rules. So it means that the harmonization effort is towards all the member states to adopt a single definition of AI systems, as much as possible, a harmonized understanding of how this is going to work in their own member states. Now, the rationale is based on the functioning of the internal market, free movement of data, if you want, free movement of factors of production, the usual factors of production, persons, goods, services, and establishment, as well as capital. And therefore, since we live more and more in the digital world, the importance to anchor the internal market into the digital world. And these regulations lays down a uniform legal framework for the development, that's important, the placing on the market, the putting into service, and the use of AI systems in the Union, in the EU, in accordance with Union values to promote the uptake of human-centric, so again towards the human being, and trustworthy AI, while ensuring a high level of protection of certain principles and certain concepts, health, safety, fundamental rights as enshrined in the Charter, including democracy, the rule of law, and environmental protection against the harmful effects of AI systems in the Union, and last but not least, to support innovation. So this is a very ambitious goal, which is an all-encompassing goal, because principles, rules, and laws are contained in the overall objective of the regulation. And that regulation is made to ensure the free movement across borders within the EU of AI-based goods and services. So we go back to the factors of production, but this time in the digital setting. Preventing, therefore, member states from imposing restrictions on the development, as we said before, the marketing, and the use of AI systems, unless explicitly authorized by the regulation. So that's the idea. The regulation is not going to regulate everything. It's going to work on the basis of the free movement of AI goods and services and AI systems, unless otherwise regulated by the regulation, by the Act. So, therefore, what are the main features of the EU AI Act? First of all, there is a certain level of banning, although it's not really referred as such in the Act, of banning, of prohibiting certain AI applications that threaten citizens' rights. And the Act refers to particular examples such as facial recognition databases, emotion recognition in certain places, particularly public places, but also private places, of course, and manipulating human behavior. So this is the scope of what is lawful and then what becomes unlawful as far as EU law is concerned. There is also the scope to limit, not ban or prohibit, but limit the use of certain AI systems, including the use of biometric identification systems by law enforcement agencies in particular. So that is also set out in the regulation. And then the regulation provides quite an extensive list of obligations for high-risk systems. There are obligations on the owners or the deployers of the high-risk systems, as well as on member states. And Particularly, we come back to the keywords across the regulation mentioned probably hundreds of times, is the word of significant harm, significant potential harm, but also significant harm, risk, impact. And not any harm, risk, impact, but significant one. Vis-a-vis health, safety, fundamental rights, environment, democracy, and rule of law, as we said before, particularly in critical infrastructures. So it's not only addressing simple spaces, but also critical infrastructures, including essential private and public services. So banking is caught, for example, which is mainly a private service, law enforcement, but also democratic processes, and so on. So to go back to what was said before about the misinformation and disinformation. And those systems, provided they are deemed of significant potential harm to any of the above, those systems must assess and reduce risks, or sometimes we also say mitigate risks, maintain use logs, be transparent, accurate, and ensure human oversight. All this. There is a right of complaints by the users and or the victims of certain unlawful actions, such as unlawful surveillance, for example, or unlawful manipulation. And there is also a right to receive explanations about decisions that are based on high-risk AI systems affecting themselves and their rights. Now, the regulation doesn't stop there. As I said, it's a long regulation. It doesn't have that many articles. However, it has a very, very long recital to start with. So the complexity of the recital shows the complexity of the whole instrument. It talks also about general purpose AI, for which transparency requirements are set out, and also about their models, and requests the compliance with copyright law and open data training materials. If the risks are found to be systemic meaning that risks can have not only an ad hoc individual impact, but can have an impact on a whole system, therefore it becomes systemic. There are additional requirements, such as performing model evaluations to assess risks, assess and mitigate systemic rights, and reporting on incidents. Because, of course, out of all the rights and principles that we named already, many of them, most of them, if not all of them, are systemic. Deepfakes also must be clearly labeled, and this is also in the regulation. And at the same time, the main feature, one of the main features of the regulation, or maybe the last main feature of the regulation, is that willingness to support innovation and small and medium enterprises, creating regulatory sandboxes and real-world testing needed at national level before being placed on the market. So that is, again, an obligation on the state, on the member state. So it is a particular type of regulation because it's, as I said before, it's generally applicable and directly applicable, but it's also very, very directive towards the states, the member states. So I use the word directive on purpose because obviously, in addition to EU regulations, the other main instrument of secondary legislation in EU law is a directive, EU directive. But EU directives, contrary to EU regulations, must be implemented into the national system. Here we have something that is a bit perhaps more like a hybrid model of regulation because it does contain obligations that are mainly on member states. Now, as I said before, the EU AI Act is an ongoing story. It just started. As I said, it was approved by the European Parliament and then went through the Council and was published in July this year. It has entered into force because the usual setting is 20 days after the publication of the Act in the official journal, unless otherwise provided. We usually give 24 months after its entry into force for member states to put into place whatever mechanisms are needed to comply with the regulation. But this regulation has some exemptions whereby less time or more time will be given to the states, to the member states. The first one is the bans on prohibited practices that will enter into force much earlier. Will apply 6 months after the entry into force date, so it's quite soon, around the corner. So what is banned? What is prohibited? There are codes of practice to be drafted, and this will be done very soon as well. And then for the general purpose AI systems or rules, including on governance, those will be also set out before the end of the 24 months. Whereas the obligations for high-risk systems will actually kick in much later, after 36 months. So there is a lot of work to be done by everyone. There is a lot of work to be done by the European Commission, first of all, to clearly communicate what is needed to monitor and to report. But there is also a lot of work to be done on the part of the member states to cope with the workload and with the changes brought by the EU regulation. Now, this is very different from the Council of Europe Framework Convention on AI and human rights, democracy, and rule of law. That is a framework convention under the Council of Europe that is open for signature to all members, all states members to the Council of Europe. And therefore, it's a different tool, but it's complementary. And in particular, it's a new tool. It was adopted in May, so very, very recently, by the Committee of Ministers and of the Council of Europe. And as I said, it's now open for signature since the 5th of September in Lithuania. It opened in Lithuania. So what is the purpose, the main aim of this framework conference, which was the result of a huge public consultation exercise? And we must say that it's the same for the European Commission's regulation proposal, was the result of a good public consultation exercise to which I participated, maybe also with Julia, I can't remember, because I did different things at different stages of the process. But that one also, it was properly, well, open enough. It's probably never open enough, but still, it was, we can say that it was quite transparent and open. It's not every day that we negotiate a framework convention, especially on AI. And the main aim here is to ensure compatibility between AI systems throughout their life cycle and human rights, democracy, and rule of law. So that's the Article 1, Paragraph 1. And for this purpose, each party to the convention is requested to take appropriate measures to ensure that aim. So it's quite broad. But those measures must be deposited to the Secretary General of the Council of Europe. And this is under Article 1, Paragraph 2, and another article later on. With a follow-up mechanism to be put in place, Article 1, Paragraph 3. Yeah, I mean, it's good to have a mechanism and follow-up mechanism. It's very important. However, follow-up mechanisms at the level of the Council of Europe are not that effective in the sense that there is no law enforcement power at the level of the Council of Europe, unlike in the EU, and particularly since the EU has used, has decided, has used a regulation. So that is a strongly legally binding document and strongly enforceable regulation. The scope of the convention is broad because it includes not only the AI systems per se, but also their risks and impacts fall under the scope, as they may be produced or arise from both a public and a private setting. So that's good. It's the same as the EU Act on AI. Now, we find the exceptions of national security interests that fall outside the scope of the convention. So that is a danger as to how this is going to be interpreted nationally. And the Framework Convention reminds everyone that this exception is subject to broader condition of compliance with international law, international human rights obligations, and democratic institutions and processes. So if there is a national security exception, that must be interpreted strictly and also justified. I believe that this is not enough for a number of, I call them derivative actors, meaning agencies that depend on public authorities or independent agencies. And whenever the private sector is actually acting on behalf of the public sector, that is probably one of the weaknesses of the convention. Research and development activities are also subject to special provisions around testing because, of course, we want research and development in that field in Europe. It's a bit like the innovation provision in the AI Act of the EU. And the convention then sets out two general obligations, broad ones, which is the protection of human rights in Article 4, and the integrity of democratic processes and respect for the rule of law in Article 5. After which, the convention sets out a number of principles related to activities within the life cycle of AI systems, and there are quite a few in the following articles. And there is an expectation that assessment takes place, as well as the mitigation of risks or adverse effects or impacts takes place. So I just wanted to remind everyone of a set of non-binding principles we have on AI, both at the level of the EU and at the level of the Council of Europe. So for the EU, these are actually were created initially by the European Declaration on Digital Rights and Principles for the Digital Decade and the ethics guidelines for trustworthy AI of the high-level expert group on AI. And they are still good law if you want. You find them in the regulation, but these principles are non-binding. As well as under the Council of Europe Framework Convention, the one we just discussed before, the new one, which clearly has a set of principles that are quite similar to the ones of the H-leg, we call it. So you find principles such as transparency, of course. You also find accountability being mentioned in both. And you find perhaps a more clearly cut principles in the Council of Europe Framework Convention vis-à-vis the work that was done at the EU level, because the work that is done at the EU level was rather technical whereas in the Framework Convention, the wording of the convention is the one that is applicable. So
I beg your pardon, Stephanie, you have 4 minutes.
Sorry?
You have 4 minutes.
Okay, no problem with that. So I just wanted to finish with this really, because I wanted to spend more time on the regulatory developments. But I wanted to look at the impact of AI on fundamental human rights in Europe and highlight the fact that this impact is cross-cutting. And this is probably something rather new. How can it be cross-cutting? It means that AI affects fundamental human rights in different ways and with overlapping violations, if you want. So AI systems can attack individual rights in overt or covert manners. So it means implicitly or expressly. Cross-cutting impact on rights via the deployment of technologies is actually quite common. And the attacks may affect primarily, but not only rights enshrined in the EU Charter and the ECHR. You know those rights because they are the usual rights that we implement in Europe, but it's good to mention them because they are common to the two instruments usually. So, of course, the respect to private life and family life, protection of personal data, but also the freedom of expression and information, which is very important, the freedom of thought to conscience and religion, the right of liberty and security, the right of a fair trial, the right to non-discrimination, equality between men and women, the rights of the child, and the principle of non-punishment without law. So the previous speech, for example, was falling clearly under the freedom of expression and information rights. There are solutions around how to protect those rights in the digital order. And we provide some in the working paper, particularly, about content moderation and the modeling of the large language or the large model or of AI systems. Particularly also looking at, if we are talking about public spaces and private spaces. But just to finish with this, which is that there is scope for new rights. When we say new rights, we mean it could be enhanced existing rights. It could be enlarged in scope of rights, but it could be also new rights. And with Julia, we provide the examples of those new rights that are not absolute rights across a comparative table in the working paper. You already know a few of them, for example, the right not to be forgotten, but we also come up with the right not to be manipulated, the right to be neutrally informed online, which go back to the previous paper, and the right to meaningful human contact. So that's all I wanted to say. I know it's a bit short, but I think I gave you enough food for thought, probably. Thank you.
Thank you very much, dear Stephanie. I already shared our working paper in chat, so I hope more people will read it. And I'm sure that all our participants now have more knowledge on AI regulation. We have some time for one or maybe two short questions because we need to give some time for our last presentators. Do we have questions for Stephanie?
May I ask? I don't know. I have some problems raising the hand function option in my Zoom. Thank you, Stéphanie, for your brilliant presentation, and really I learned so much from your presentation, both on AI and human rights and both on EU law. So that's really very much educative. And I have one question, maybe like two short questions. Since the EU regulation on AI is based on human rights-based approach, does it consider the private actors' obligations in this sphere? And the second question, do you think that EU regulation on AI can also be applicable in situations which related to the armed conflict, like AI and modern wars?
Yeah.
Thank you.
Thank you, Katerina. So the first question, it's actually the EU AI Act does not really approach the matter via a human rights approach. It's rather a risk-based approach. So that way, it's easier, in inverted commas, to catch the private actors. Okay, so private actors are indeed subject to a number of obligations under the Act. And as I said, regulations in the EU, they apply to everyone, any citizen, any company, anyone, you ought to know. So this is the good thing with regulations. But as we saw, it has many different implementation stages and many challenges ahead regarding this. Now, the second question is, of course, very important and very interesting. So there is that national security exception, definitely also in the EU AI Act. There was a tendency in the past to distinguish what we call misuse, in other words, distinguish the civil use of technology from the military use of technology. And this is something that probably is also in the Act. I must say that, the Act is so long that it's difficult to actually confirm this, but you're right that this is an important possible misuse of the regulation and of AI systems, to which we will need to also pay attention. Yes, there used to be a regulation. No, sorry, I'm not sure whether it was regulation. There used to be a whole set of measures applying regarding misuse. So misuse or double use, both for civil and for military purposes. So I think you could perhaps take the EU AI Act and do a Control F, across the 1,000 pages, and enter misuse or double use, dual use, and see what comes up